Hey, everybody. Welcome to Thursday Night Live. We're here each and every Thursday evening where we discuss all things debt related, whether it's debt collection lawsuits, whether it's bankruptcy, wage garnishment, all that kind of stuff. I'm here to do our live session to answer questions and to discuss what you guys want to discuss. The whole point of this is to talk about these topics. Put your comments in the chat area there. I'll put them up on the screen and we can go over there and discuss them and talk about the different ways to address different debt issues. My name is John Skiba. I'm a consumer protection attorney and a bankruptcy attorney in the state of Arizona. And we do this, and while I offer information, it shouldn't be considered legal advice. If you need an attorney, particularly in your state, if you're in Arizona, I hope you'll call me. But if you're not in Arizona, you need to get legal advice from an attorney in your state. I don't know the rules in every single state. I know them here in Arizona. And so you should just take it for what it is. It's information and does not create any type of attorney-client relationship. All right. Again, one thing I wanted to talk about before we jumped into the questions tonight is the Facebook group. I'll put that up here on the screen. I have a Facebook group. There's no charge. There used to be in times past. Now you can just go over to Facebook, check out Consumer Warrior in the groups. You do have to, it's a private group. So I'll approve you as they come in. Be patient with me. Sometimes I'm busy doing things related to my law practice, but I'll get you in there. It's a great place to bring up questions, not only for me that I interact, but with other people who are going through a similar situation. Also, if you are on the YouTube stream, you can see there at the top, I have a link to my online templates, tutorials, and kind of a deeper dive in all these topics, particularly related to defending a debt collection lawsuit if you're going that alone, as well as some bankruptcy and debt settlement things. So if there are questions, go ahead and put them in there. We will put them up. We have our regulars here. We got Dave Lamb supporting the channel tonight. Thank you, Dave, as well as Marcos. You made it. We got you here. I know it seems like for the last few weeks, Marcos has said he just barely missed it. So glad you could check in tonight. I want to also thank Alex. Alex is here each and every week supporting the channel, encouraging people to get out and like the Consumer Warrior YouTube channel. So thank you for that. I wanted to start off by addressing a couple questions I get related to bankruptcy. This first one, I get a lot. People say, how far behind on my credit cards do I need to be before I can file for bankruptcy? So if you're finding yourself needing to file Chapter 7 or Chapter 13 bankruptcy, and you're dealing with a lot of credit card debt, I run into people very frequently who have they're keeping their monthly minimums and they're just reaching their breaking point, and they need to file. They need to get some kind of relief. They realize they can't continue on like that. And so I get the question of, hey, should I be behind 3 months before I file? Because a lot of times when you're doing debt settlement or you're trying to just negotiate a debt, they don't really engage with you unless you're actually behind. The same is not true for bankruptcy. Surprisingly, for a lot of people, you don't have to be behind at all. And actually, people who have kept their credit cards current and then file for bankruptcy, and they're going to have a lesser credit hit because it drops you 100 to 150 points. But it's, wherever you're starting, it's going to drop you that far. So if your credit's at like a 650 or 680 or even higher, you're not going to see a big of impact early on as far as how much of a hit you're going to take to your credit. So that being said, my general rule of thumb is if you decide to file bankruptcy, and if you decide 100% I am going to do this, you've talked to a bankruptcy attorney, you're moving forward, I would not generally pay any more money to credit card companies because that will not benefit your score that greatly. It will, the debt's going to be discharged. It's going to go away. On the flip side of that, you shouldn't continue to use your cards either once you know that you're going to go ahead and file for bankruptcy. All right. Let me just touch one other quick question that I got off of the channel. Sorry, I do the producer, everything else on this thing. Because I got a question on this one that was also bankruptcy related that I wanted to address because I get this a lot. The other one was, how much debt do I need to file for bankruptcy? This is another one that's kind of surprising. The answer is, I guess, zero. You don't have there's no specific dollar amount. You don't even have to have debt. I don't know why you'd file bankruptcy without debt, but it's possible that you don't even really have to have debt. And I actually, now that I'm saying that out loud, I can think of times when I have filed bankruptcy for clients who didn't really have a whole lot of debt. They may have been in a situation where they're behind on their house payment. I had a client recently, she was behind on her house payment and needed to be able to get caught up. Her house was going to go into foreclosure, but like she had like $500 in credit card debt. There wasn't a whole lot of that type of debt, but you're able to file the bankruptcy, stop the foreclosure, and bring the house payment current and stop that foreclosure sale for most of all. So there's no specific dollar amount you need to have. When people start hitting $20,000, $30,000, $40,000 in credit card debt, particularly if they're unable to make any kind of serious ability to repay it, then we start looking at a Chapter 7 bankruptcy. I always say, one time I remember I filed a bankruptcy at Chapter 7 for someone who had $8,000 in credit card debt, which is fairly low when it comes to filing for bankruptcy, but it may have well been $8 million. Her personal situation made it such that there would never be very much income coming in, and it was really just trying to get these people out of her life so that she could kind of move forward on that. I've also had it the other way, where clients have had $100,000 in credit card debt, and we were able to actually put something together as far as a settlement because they were in a situation where they actually had enough funds to be able to go ahead and take care of that. So, all right, let's, with my questions out of the way. All right, Natus, thank you very much for supporting the channel today. Let's see. Alex had a question. Have I ever had to appear down in Yuma, Arizona? I've had cases in Yuma, Arizona. I think I have a couple right now in Yuma, Arizona. For those of you not familiar with Arizona, Yuma is way down on the southern border of the United States, southern border of Arizona. I'm in the Phoenix area. My office is in Mesa, Arizona. So, Alex, you'll have to correct me. I think it's about 4 hours, 3 hours down to Yuma. It takes a while to get there. I usually pass through there on my way to San Diego. But I've appeared there, but not in the courts physically. COVID has done kind of a funny thing with the court system in that before COVID, judges did not like telephonic appearances or video conferencing, something they really push back against. And I've seen now the courts kind of do a 180 on this, and they're really embracing it. I think they realize that their lives are a lot easier if they're not having a million people in the courtroom all day long. And so what we're seeing is I can appear in places all over the state of Arizona now much more easily, which helps us to represent additional clients. So, all right, Natus, let's talk about your question. Sounds like this is a situation where there's a debt collection lawsuit. You file a motion to compel private arbitration, and then often the judges will either dismiss the case or they'll stay the case while arbitration is pending. Here it says arbitration stayed. After 4 months, none of the parties file for arbitration. Will the case go to trial? Should all settlement offers be done written, or is it okay to call and negotiate? Two good questions there. So if you've been sued by a debt collector and you're invoking the arbitration clause, if you don't know what that is, go back and look at some of my other videos. But and I also have a tutorial on it, one of our most popular tutorials and templates that we have. And there's a link pinned to the top of the chat section there. If you file a motion to compel private arbitration, which is essentially taking it out of the court system and pushing it into the private arbitration system, which the debt collectors and debt buyers do not want to do. If the court does that, if they just say, okay, we're going to stop this litigation, go ahead and file it. But if nobody files it within 4 months, usually what happens at that point is the court can then essentially remove the stay and push the case forward to an actual trial date. So if you're in a situation where the case has been stayed so that arbitration can take place, you either should file it or you can put some pressure on the collector to file it. For you to file it, the fee is relatively minimal. These are done through private arbitration companies called AAA, which is the American Arbitration Association, and JAMS, which is the other one. It's an acronym. I can't remember what it stands for, but they're both private arbitration companies. And the consumer fee is about $200. I think if you take that step to actually file it, you're going to see them walk away from this fairly quickly. As to your second question, when you're negotiating settlement agreements, often with attorneys, we either do it via letter or usually even email. There are often times where I'll reach out to the creditor and negotiate a settlement. The main thing I would say is even if you call them and have it set up, do not pay any money until you get some kind of verification of that or confirmation of that settlement in writing. Most law offices should be willing to send you an email, a letter that says, okay, if you pay this amount, this account will be settled in full and it'll be done. And so I would not pay a penny to anybody that isn't willing to do that, because you run the risk that if you don't have confirmation of it in writing and you send money over, that they just count it as a payment towards your thing. So, All right, let's see here. Someone had a question. Can I buy your motion to compel for dismissal and file for arbitration in Tennessee for a payday loan? So the motion to the tutorial I have on there, that's the how to win your case through filing a motion to compel private arbitration. It'll work in debt buyer cases, original creditor cases. The only thing that you have to look is to see is if you have an arbitration clause in your contract. Now, the payday loans, my guess is that they likely do. The reason why these arbitration clauses are in there is because the creditor, the plaintiffs, they are trying to avoid class actions, and they do that through this arbitration clause. And so you can use that to your benefit. So look at your original agreement or your promissory note. If there's a private arbitration clause that says that disputes can be resolved through private arbitration, then the course will work fine for what you're trying to do there. All right, let's see here. This can happen sometimes. Ape Wrench here says, I chose the private arbitration strategy against absolute resolutions. They're a junk debt buyer. After filing the motion to compel and opening a JAMS case, the judge denied it and scheduled a pretrial conference. What you're dealing with there is just the frustration of litigation. The court should not deny this. This is absolute resolution's contract. They're saying, hey, we got this from Synchrony Bank or whoever they're getting it from. They're bound by the same terms. They are saying we're stepping into their shoes, and so that's why we should even be able to get payment. And so the court should do it. I mean, you could file a motion to reconsider. To me, it's an appealable issue. The courts, there should be almost zero discretion. I usually see courts excited about this because these courts are dealing with thousands of these debt collection cases, and they just want to get rid of them. So, all right. Let's see here. We'll go down here. See what Dave has to say. When I filed my Chapter 7, my attorney actually asked me for all my cards. One by one, he asked me if I wanted it back. As I said no to each, he shredded them. I was current on all of them. That's a unique approach to do it. I've never taken anybody's cards. I do tell them that you can't go out and use them. If you know that you're going to file for bankruptcy and you continue to use your cards, it can they could consider that fraudulent because you're incurring debts that you know you're not going to pay back. Which, frankly, that's what I use as kind of my test when people come to me and talk about the morality of bankruptcy. I totally get that. I think we all, most people want to be honest. They want to pay their debts. The differentiation is if someone incurs debts knowing, that they're going to file bankruptcy. If you incur a debt and you're like, yeah, I'm just going to file bankruptcy in 2 years, whatever, that's problematic to me. Whereas if, you're just living your life and life happens and medical and COVID and job loss and everything else, that's completely different. So, all right. Let's go back to Ape Wrench's thing. In my case, they denied private arbitration and scheduled a pretrial conference. What can I expect? If this is in Arizona and my gal, look at that. I just got to look down a little bit further. He's in Arizona. Pretrial conferences in Arizona are fairly, they're just kind of routine. Usually they're 5-minute things. A lot of times now they're being done over the phone. And often the court's not even involved. And so if the court is involved, if you show up to the pretrial conference, the judge will generally ask, okay, where are we at? That's the kind of question you're going to get. They may ask if the parties want to discuss settlement. When we were appearing in courthouse, they'd often say, okay, go into the hallway and discuss if there's any chance for settlement. If not, come back in and we'll set this thing for trial. When you do it over the phone or virtually, they have a little form you fill out and you'll be able to say, yeah, we reached an agreement, and we'll submit some paperwork, or it'll say, no, we didn't. Go ahead and set the case for trial. I usually ask for the case to be set out at least 90 to 120 days to give you time to prepare for that. So, all right, let's see what here. Let's see. I have not worked since September 2nd. Recently, bank raised the credit card limit, but I don't think it's good or legal to use it to get by for a few months, even if it's a year till bankruptcy trustee can see it as fraud. I can tell you who will see it as fraud is more the credit card company. And this kind of goes back to my question. To me, there's the legality of it, the morality of it. I would not recommend doing that. I think that you could cause yourself some problems. It's the credit card company that would have to come in and raise an objection to it. They would have to say, look, This debt should not go away. It was incurred through fraud. They've had it. I mean, it's a tough burden they have. They have to come in and show that you incurred debts with the knowledge that you're going to file for bankruptcy, particularly even if it's a year. I mean, how are they going to be able to prove that? That's going to be tough. So that's what I'm saying. The things kind of get into a little bit of a gray area. My general rule is if you know you're going to be filing, I would not continue to incur any additional credit card debt. So, all right, let's go to Mark here. Midland attorney is suing me, put in an affidavit from Florida saying it will follow the New York court rules about synchrony bill of sale. The attorney's from New York, but her license there was suspended 2 days prior to this. How would I approach this affidavit and the attorney? So if we go back to the original question, they put an affidavit from Florida saying we'll follow the North, and I'm assuming that you are in Florida. The attorney's from New York. Okay, you're in. All right, you're in Ohio. So, the thing with all that is stuff like that, like, which rules are going to be followed. That's very state specific. And usually procedural rules are followed by the state that the court's in. It's unlikely that they're going to file a case in Arizona and they're going to say, okay, you're going to follow the rules of civil procedure from California. That's not going to happen. The courts are going to apply procedural rules from Arizona. Sometimes there can be what are called choice of law provisions in some of these contracts, and you're looking at they'll follow a substantive law from somewhere else. As far as that affidavit goes, I guess the only way to attack an affidavit is if they're attaching to something like a motion for summary judgment. You're not going to see if they try to submit it at trial, it's hearsay. You can object to hearsay. But if it was submitted like with an affidavit or a motion for summary judgment, you could ask the court to strike it if it's not something where it's applicable to your particular state's rules of civil procedure. So, all right. Let's see here. Let's go. Who reports a bankruptcy to your credit? So once you file bankruptcy, it will show up in the public record section of your credit report. So if you pull a credit report, and you can do that, you can go to annualcreditreport.com. You can get a free copy from all three major credit reporting agencies, TransUnion, Equifax, and Experian. And that website is kind of a quasi-government site. It used to be you could only pull that once a year for free. Under the CARES Act, and COVID, I don't know why it impacted this, but you can now pull one once a week. It does not have your score on it, but it does show you your creditors, how they're showing up, and you'll see there'll be all the listing of your creditors and all the information on payment history. And then there's a public record section. If you file for bankruptcy, it'll show up there. It's the court. And I'm not going to, I don't know the mechanics of it. I believe that because it's a public record when you file bankruptcy, as far as people can request it. And it's my understanding that the credit reporting agencies request that information from the bankruptcy court, and then it's reported on your credit report for 10 years. With the Chapter 7, it'll show up. Something as well with that public record section a lot of people aren't aware of is that judgments do not show up there anymore. It used to be that you'd see things like not only bankruptcy, but judgments. They no longer appear. Back in summer of 2017, they changed the rules on that. Said there were just too many problems with personal information not being on the judgments. Frankly, they're, if you had a common name, you'd see a judgment showing up that's not yours. And so the rule is unless your social security number is on the front of the judgment, they can't list it in the public record section, and that never happens because that would violate a whole bunch of other problems. So, all right, let's see what we have here. They probably get it from PACER. PACER is the public access to courts, something or another. I should know all these acronyms, but I don't. But PACER is the federal court system of how they obtain that information, and they're likely to access that through there. So, all right, let's talk about this one. If you pay a charge off, will your credit score increase at all? Generally, yes. Going back to one of the largest misconceptions that are out there, the charge off. If a debt is charged off, it does not mean it's uncollectible. Doesn't mean that they can't still sue you for it. It's just an internal tax classification for the creditor. Once an account or credit card goes 180 days with no payments on it, it's charged off. And often that's when debt buyers will sell it, or the original creditor will sell it to debt buyers, that kind of thing. If you pay the charge off, so if you have something that's showing up, it's in collections at that point on your credit report, the newer it is, if it just recently was charged off and you settle it or pay it off, you're going to see a pretty significant increase. If it's been in that way, because it'll stay, derogatory information on your credit report stays there for a little over 7 years. So if you're like 6.5 years into it, you're probably not going to see that big of a jump just because the damage has been done at that point. You'll still see a little bit, but if you pay it off in full, you may get a little bit of a bump. And then if you settle it, it'll show up as settled for less than amount owed. If you can get them to delete it completely, that's going to be a benefit to you. Some creditors will push back on that. They claim that the Fair Credit Reporting Act bars them from doing anything other than stating, exactly what happened. My counter to that is the FCRA doesn't even require them to show it at all. So, all right. I think that will about do it. So I appreciate everybody checking in as always each and every Thursday night. Again, if you have interest in joining our Facebook group, there's a lot of great people there now. I think we got almost 100 people there. And so that's a great place to raise questions, raise strategies, kind of discuss different ways to deal with a lot of these debt collection lawsuits and the kind of stuff that you're dealing with there. All right. That is going to do it for this week. I appreciate y'all checking in.